What is the dispute in the South China Sea? There is a territorial dispute that is rooted in conflicting territorial claims over islands, rocks, and reefs above water at high tide. So there is a territorial dispute separate from the maritime dispute that is rooted in conflicting maritime claims over maritime zones. The dispute involves 6 countries bordering the South China Sea: China, Vietnam, the Philippines, Malaysia, Brunei, and Indonesia. Indonesia is involved only in the maritime dispute. All the disputant states are parties to UNCLOS. Now, UNCLOS is the constitution for the oceans and seas of our planet. It's the greatest achievement of man in terms of codification of international law. China's 9-dash lines claim, to which China is aggressively asserting indisputable sovereignty to all the islands and waters enclosed by the lines, is the main driver of the South China Sea dispute. China's 9-dash lines claim encloses 85.7% of the entire South China Sea. It is equivalent to 3 million square kilometers out of the 3.5 million square kilometer surface area of the South China Sea. China continues to mass produce warships at a faster rate than any other country in world history during peacetime. What will China do with all of these naval assets? Only one purpose. The primary purpose is to enforce its national boundaries in the South China Sea, to push everybody out of the South China Sea in terms of sovereignty. Now, let's go to low tide elevations, because this is a very important feature in the dispute. A low tide elevation is a naturally formed area of land, whether it's a rock, reef, or atoll, or sandbar, surrounded by water, above water at low tide, but submerged at high tide. So at low tide, you see it. At high tide, you don't see it because it's covered by water. So graphically, that's the this is the low tide elevation. At low tide, you see it. At high tide, it's covered by water. This one is a high tide feature. This is entitled to a territorial sea of 12 nautical miles. This one is not. And this is an island. If it is capable of human habitation, it's entitled to 12 nautical miles plus 200 nautical mile exclusive economic zone. Is the Philippine arbitration case against China a territorial or a maritime dispute? It is only solely a maritime dispute, and the number one issue we raise against China is whether China's 9-dash lines, which are not measured from land, can encroach on the 200 nautical mile EEZ of the Philippines. Because every state, coastal state, must measure its territorial sea from land. So 12 nautical mile territorial sea, 200 nautical mile EEZ, and an additional 150 nautical mile continental shelf if you can prove a natural prolongation of your continental shelf. We are not asking the tribunal to rule who owns, who has sovereignty over certain islands or rocks above water high tide. We are asking the tribunal to rule what are the maritime entitlements of these geologic features, whether 0 nautical mile, 12 nautical mile, or 200 nautical mile. Let's go to China's reclamations in the Spratlys. China occupies 7 reefs. It is reclaiming on all 7 reefs. China is saying the purpose is civilian. This is not a military installation. But of course, China is saying we have to protect also. I mean, it's only logical that installations, whether even if civilian, must be protected. So there can be military facilities there. This is similar to China's explanation in 1995 when it occupied Mystery Reef. China said the purpose is to provide a shelter for its fishermen. That shelter turned out to be a military garrison. China is now reclaiming Mystery Reef and turning it into at least a 500-hectare military facility. Let's go to the reclamations. This is Fiery Cross Reef before the reclamation. It's 1 meter above water at high tide. It is outside the Philippines EEZ but within our continental shelf. So being above water at high tide, it is territory. There's a territorial sea, there's a territorial airspace. Next slide. This is how it looked like January 28. These are the dredgers of China sucking the sand from this lagoon, putting it along the reef. This will be the harbor for the naval vessels of China. This will be the runway. This is the apron of the runway. Next slide. Pilot Cross Reef, May 7. Next slide. Pilot Cross Reef, April 17. That's Johnson South Reef before the reclamation. It is within our EEZ. Next slide. That's how it looked May 9. This was forcibly seized by China in 1988. It was formerly occupied by Vietnam. And in that naval skirmish, about 77 Vietnamese soldiers died. Next slide. That's Makinan Reef. It's a low tide elevation within the EEZ of the Philippines before the reclamation. That's how it looked like May 5. And you can see these big buildings here. It's 5 to 6 stories. Maybe this will be the command and control center for the maritime Silk Road of China. That's Makinan Reef, May 28. Haven Reef, this is a low tide elevation outside our EEZ but within our continental shelf. That's how it looked like. Another 5 to 6 story building. Haven Reef as of May 28. That's Quarteron Reef before the reclamation. This is outside our EEZ but within our continental shelf. That's how it looked like May 7. There's a ship here. Tower, again, the tall buildings, 5 to 6 stories. The Subi Reef before the reclamation, outside our EEZ but within our continental shelf. This is a low tide elevation, but high tide is completely submerged. That's how it looked like May 6. There's another runway. That's Mischief Reef before the reclamation. This one is close to Palawan. Only 125 nautical miles from Palawan, within our EEZ, seized by China in 1995. When China seized it in 1995, we were wondering, what will China do with a feature that's totally submerged at high tide? That's before the reclamation. That's as of March 16. If China closes the reclamation here, that will be 500 hectares. That's bigger than Mandaluyong City. China can put their air and naval bases and can garrison thousands of troops. Very strategic place. It's between Palawan and the Spratlys. Next slide. That's Mischief Reef, May 11. Mischief Reef. So it looks like they are going to close it here. It will be about 500 hectares conservatively. Some have estimated it to be 750 hectares reclamation. Now, Mischief Reef is between Palawan and the Spratlys. So, if they put up an air naval base and garrison thousands of troops here, our naval commanders are worried because they will have a hard time resupplying our islands here. Once you have an air and naval base here, our Union Shoal will be difficult to maintain because China will block all supplies to our Union Shoal. Now, China has a air base in the Paracels, Budi Island. It's 2,700 meters. It can take in any military aircraft of China. So that's in the Paracels. Their only naval air base in the South China Sea outside of Hainan. So China will have an air base here. It will putting up one in the Spratlys, and I anticipate China will put up one in Scarborough Shoal. It will have a triangle of air bases. They will now enforce an ADIZ, an Air Defense Identification Zone. And an air and naval base in the Scarborough Shoal, I think, is desirable for China because here in the Bashi Channel between Taiwan and the Batanes, that is the only outlet of China's submarines and warships to go to the to the Pacific. Now, what happened in since 1946? Before the war, the southernmost territory of China was Hainan. That's it. It had no territory further south of Hainan. After World War II, when the Japanese left the paracels, China seized the Amphitrite group of the paracels. So China moved its southernmost defense perimeter further south. In 1974, in the dying days of the Vietnam War, China seized from South Vietnam the present group of the paracels. So China moved again its southernmost defense perimeter. In 1988, China seized Johnson South Lee from Vietnam. China moved very far to the south, its southernmost defense perimeter. In 1995, China seized Mischief Reef from the Philippines, moving it further south, towards the 9-dash line. In 2012, China seized Scarborough from the Philippines. And 2013, China seized Pilipinong Shoals from Malaysia. So China has moved its defense perimeter further south towards the 9-dash line. So for 21 consecutive years, Chinese defense spending has grown by double digits, and that has made it confident that it can now enforce the 9-dash lines as its national boundaries. That's Mischief Reef. It takes 30 million years for nature to form a reef like Mischief Reef. 30 million years. Man left East Africa only 60,000 years ago. So it's just a blip in the creation of a reef. 20% of the fish we catch in the wild every year breed in these Spratlys. 20%. And the eggs and larvae spawned here in these reefs, in the Spratlys, are carried by tides all the way to Sulu, to Indonesia, to Brunei, to Malaysia, to Luzon, to Vietnam. So these are important sources of food for all the littoral countries in the South China Sea. China destroyed 7 huge reefs in less than 2 months. UNCLOS says states have the obligation to protect and preserve the marine environment. China's massive and wanton reclamation of the Spratlys destroyed the marine environment. So I have recommended that we should ask for provisional measures because, one, the reclamations of China are covering the low tide elevations. They are suppressing the evidence because we want to prove to the tribunal that these are low tide elevations, but China covered them permanently with sand. So that's in prejudice of our rights. And also, nobody will dispute this, that the reclamations are causing serious harm to the marine environment. So we have a ground to ask for a provisional measure. And there is also a duty of coastal states in semi-enclosed seas. South China Sea is a semi-enclosed sea because 80% of the waters are either territorial or EEZ waters. Now, Article 123 of UNCLOS says, coastal states in semi-enclosed states must cooperate with each other in the exercise of their rights and in the performance of their duties with respect to the protection and preservation of the marine environment. In other words, before China conducted its reclamation, it should have consulted with all coastal countries. Now, Chinese reclamations on submerged areas in the EEZ and continental shelf of the Philippines are illegal because UNCLOS expressly mandates that it is only the coastal state that can undertake such reclamations in the EEZ and continental shelf. A basic principle in international law, as well as in all national legal systems in the world, is that no legal right can arise from an illegal act. No legal right can arise from an illegal act. China cannot invoke the exception of military activities or law enforcement activities to justify or escape from its illegal act of reclamation. Because its reclamation is illegal, China cannot invoke any lawful justification for that. Now, who can create artificial islands or wreck structures on the LPEs and EEZs? Okay. Only the adjacent coastal state. That's very clear under UNCLOS. Let's go to this specific provision because this is very important. Article 60, Part 6 of UNCLOS on artificial islands, installations and structures in the exclusive economic zone. In the exclusive economic zone, the coastal state shall have the exclusive right to construct and authorize and regulate the construction and operation of artificial islands, installation structures for economic purposes, the coastal state shall have exclusive jurisdiction over such artificial islands, installation structures. That's very clear. How about in the continental shelf? Article 80, Part 6 states, artificial islands, installation structures on the continental shelf. That is beyond the 200 nautical miles from the sea. Article 60, the one that I read earlier, applies. All things being equal to artificial islands, installation structures on the continental shelf. So, in both the EEZ and the continental shelf, it's only the coastal state. And the Philippines is a coastal state. So, all other countries, if they put up structures there or artificial islands, that's illegal. And they cannot claim a legal right out of an illegal act. China tries to justify its reclamations by freedom of the seas. Freedom of the seas includes the freedom to construct artificial islands and other installations permitted under international law, but it's subject to Part 6, and Part 6 is what I read to you. If the Philippines can prove that its continental shelf from Palawan has a natural prolongation, then we are entitled to an additional 150 nautical miles from the outer limit of our EEZ. What China is doing is reclaiming, and it is now an island, permanently above water at high tide. Will they have a territorial sea, or a territorial airspace, or an EEZ? No. Because UNCLOS says an island is a naturally formed area of land surrounded by water and above water at high tide. In fact, it specifically states artificial islands, installation structures that possess the status of islands. They are not islands. They have no territorial sea of their own. And without a territorial sea, they have no territorial airspace. So, to summarize, artificial islands reclaimed from LTEs beyond the territorial sea, like Mischief Reef, Johnson South Reef, and Subi Reef. They are not islands or rocks above water at high tide. They have no territorial sea. They have no territorial airspace. They do not have EEZs or continental shelves. If illegally constructed, as China has done, they do not even have a 500-meter safety zone. Because if you put up an oil rig within your EEZ, beyond your territorial sea, that is a safety zone. But if it's legal structure, it doesn't even have a safety zone. A reclamation on a rock above water at high tide, such as Fiery Cross Reef and Quarteron Reef, is an expansion of land territory. A rock above water at high tide is land, it is territory. So you can reclaim it. Because it has a territorial sea of 12 nautical miles, you can reclaim up to the edge of your 12 nautical miles. Reclamations tamper with the evidence. How can we prove now that Mischief Reef, Gable Reef, Subi Reef, and Makinip are low tide elevations? China has covered them already with sand above water at high tide, which can still prove. Because China's own nautical charts before the reclamations designate these four features as low tide elevations, just like our nautical charts. The nautical charts of other countries such as UK, US, Japan, Russia, and Vietnam are unanimous in designating these features as low tide elevations. Now, can a state claim historic rights to maritime zones? China is saying we have historic rights over the entire South China Sea, even if it encroaches on the EEZ of the Philippines, Vietnam, Malaysia, or Brunei, or Indonesia. No, that cannot be done now, because when the UNCLOS was negotiated, and China actively participated in the negotiations, what is China saying now? China is saying, oh, we are entitled to 200 nautical miles from our coast, but we also have historic rights over the rest of the South China Sea. They cannot do that anymore. They signed the convention. They knew what they were signing. No country has ever claimed an entire sea. China is the only one doing it. Is there a legal basis under international law to China's 9-lines claim? No. Because the principle embodied before UNCLOS and even under UNCLOS, the basic principle is that the land dominates the sea. Before you can claim sea, you must have land. Land is the source of your power to claim the sea. This means that for non-archipelagic states like China, all its maritime zones must be measured from baselines along its coast. China's 9-lines are not measured from baselines. We do not know how China measured them. China has not explained to the world. So, China is saying our waters under the 9 dash lines are sui generis, one of a kind. If it's one of a kind, it is not territorial sea. It is not EEZ, it's continental shelf. But China is not explaining why, how. Why are you entitled to the entire South China Sea? The high seas have always been part of the global commons. Whether before or after UNCLOS, the high seas could not be subject to sovereignty by any state, whether before or after UNCLOS. UNCLOS declares the high seas are open to all states, whether coastal or landlocked. Freedom of the high seas includes freedom of fishing. No state may violently purport to subject any part of the high seas to sovereignty. So, landlocked countries like Laos, like Austria, like Switzerland, like Nepal, they have a right to fish in the high seas. And the South China Sea has high seas. 20% of the South China Sea are high seas waters. The world has a right to fish there. Nobody has the right to bar other states from fishing in the high seas. But what has China done? Now, this is the high seas. 20% of the South China Sea is high seas. Beyond the EEZ are the high seas. All the fish in the high seas belong to mankind. It's part of the global commons. All states have a right to fish here. But China has said, these are the waters administered by Hainan, the province of Hainan. It includes the high seas. By appropriating for itself the fisheries resources in the high seas of the South China Sea, China is committing a grand theft of the global commons. All states have a right to fish there. In Palawan, the issue is whether Ito Aba, the largest island in Spratlys is Ito Aba. It is about 46, 47 hectares. And China is claiming it has an exclusive economic zone because Ito Aba is capable of human habitation of its own. Assuming that Ito Aba is capable of human habitation, it will be entitled to a 200 nautical mile around it, and it will overlap with the 200 nautical mile EEZ of the Philippines. This is the overlap. Now, our coastline in the overlap is 495 kilometers. Ito Aba's coastline in the overlap is only 1 kilometer. Now, what is the rule under international law? The rule is pahabaan ng coastline. The country that has the longer coastline wins. In the case of Nicaragua versus Colombia, the court said the overriding criterion is the length of the opposing relevant coastlines in the overlapping maritime zones. A ratio of 1 is to 8.2. For every 1 kilometer coastline of Colombia, Nicaragua has 8.2. And the court said that is a substantial disparity. Colombia is not entitled to any EEZ facing Nicaragua. In Palawan, the ratio is 1 is to 495. It's not only substantial disparity, it's total disparity. So we should not be afraid. When this is brought before a conciliation commission, they will apply this principle. And Ito Aba, if it is declared to have an EEZ, it will get an EEZ seaward facing the South China Sea. Now, in 2002, ASEAN and China signed the Declaration of Conduct. It says, the South China Sea dispute shall be resolved in accordance with universally recognized principles of international law, including the 1982 UN Convention on the Law of the Sea. In other words, the South China Sea dispute shall be resolved in accordance with international law. And the primary law is UNCLOS. Now, so we filed our case before the tribunal because that's in accordance with UNCLOS. And after we filed, China said the dispute should be resolved in accordance with historical facts and international. They now inject historical facts. But we are game. Okay, let's go into the historical facts. We gladly accept China's invitation to look at the historical facts. We examine China's so-called sovereignty markers in the paracels and the Spratlys, ancient maps of China, the Republican constitutions of China, and the actual historical claims, the narrative of China and Philippines with respect to Scarborough Shoal. China always says that they have abundant historical evidence to prove their indisputable sovereignty to the South China Sea, the islands and the waters. Now, a noted French geographer, François Bonnet, was made an extensive research in the South China Sea dispute, exposed in a forum at the Ateneo Law School March 27, that China actually planted its so-called abundant historical evidence in the Spratlys and the Pamantasan. Okay, let's go to the ancient maps of China. It's the oldest map I can find, 1136 AD. Why is it still in existence? Because it is engraved in stone. And it shows Hainan Island as the southernmost territory of China. The next map of China, Ming Dynasty map, it shows Hainan Island as the southernmost territory. Now the next map is the 1896 map, entitled the Qing Empire's Complete Map of All Provinces, and it shows Hainan Island as the southernmost territory. They had to put it in inset. A very important date, 1896 map, because when the Qing dynasty ended and the Republican government was installed, the Republican constitutions of China after that all stated that the territory of the Republic of China is the same as the territory of the Qing Empire. And this is the territory of the Qing Empire. It ended in Hainan as its southernmost territory. Okay, this is the Philippines, the oldest map I can find showing Scarborough Shoal. This is the 1636 map. P. de Mandato, that is not the name of the shoal. P. de Mandato is point of command, so there must have been a Spanish military garrison along the coast. And all other maps of European cartographers showed Scarborough Shoal without a name until 1734, when Father Murillo Velarde made this map. It shows Scarborough Shoal as Panakot. The first name ever given to Scarborough Shoal is Panakot, a Filipino name. Tagalog name means danger or threat, because if you don't know where it is, you are a captain of a ship, you will hit the rocks and your ship will sink. And that is what happened to Scarborough. The tea clipper ship of Britain, Scarborough, sank or hit the rocks and ran aground. That's why in European maps it's called Scarborough Shoal. Now it also shows Los Bajos de Paragua. Paragua is the old Spanish name of Palawan. Bajos means shallow waters. So the shallow waters of Palawan, these are the Spratlys. So in 734, the Spratlys appeared as part of the Philippines in this map of Father Murillo Velarde. This is China or Vietnam has no map earlier than this showing the Spratlys. We have the oldest map. And this is not even our oldest map, because there's a 1690 map that I found showing the Spratlys as part of the Philippines. But it was made by a European cartographer. This one was made by a Filipino, here in Manila, printed in Manila. The engraver was a Filipino, Bagay de la Cruz, and the one who drew it, Francisco Suarez, was a Filipino. Printed here. And in 1762, the British invaded Manila, they looted Manila, they left, and they brought with them the copper plates of the map of Murillo Velarde. And when they reached London, they reprinted it, and that's how the Duke of Northumberland bought that map, which a Filipino bought, will donate to the National Museum. So that's the story of the map. But the British, when they ran out of coppers, they melted the copper plates of the map to print, to make their own Admiralty charts. So we don't have those copper plates anymore. And this is very famous map, the mother of all Philippine maps. I thought that I only heard legends that there was a Filipino who owned this map before the new one was acquired. Well, he called me last week and he showed me the original. And that map was printed in Manila, 1734 map. The one that was bought recently from the Duke was printed in London. That's why when the British took the copper plates, this one was probably one piece, but the vignettes here, there's 6 here, and 6 years, they were separate. So when the British reprinted it, they did not get the exact arrangement. That's why if you look at this map and this map, it has a different arrangement of the vignettes than the one that was purchased from the Duke of Cumberland. So that's a little trivia. So maybe next year the map can be brought here and permanently exhibited at the National Museum so that every school children can look at it and see that Scarborough Shoal belongs to the Philippines. And one day they have to recover it for the Philippines. And we have here the Spratlys. I have not found any Chinese or Vietnamese map earlier than this that shows that Spratlys is part of their territory. Because it was a very famous shoal, in 1792, Alejandro Malaspina came here and surveyed the shoal. Who was Alejandro Malaspina? Alejandro Malaspina was an Italian navigator who served in the Spanish Navy, and he was chosen to head the Spanish scientific navigation. So Malaspina came here, and in his journal, 4 May 1792 journal, on this shoal, Spanish and foreign ships that they lost. A very famous shoal. We are the only country that have documented all of this. Next slide. 1867. It shows it has now a name, Scarborough, Bajo Basilio. Spanish, this is a Spanish map. Those are not the only maps. I just had to compress it. I have a catalog of all these maps, so many maps showing Scarborough Shoal as part of the Philippines. But I cannot present all of them here. We now come to the American era. We first came here in 1898 when they defeated the Spaniards. The first map that they came out with is 1899 map, this one. And it shows Bajo de Masillo. And it shows United States Coast and Geodetic Survey. So, an official map of the U.S. They know that Scarborough Shoal is part of the Philippines. Next map. 1933 map, Scarborough Shoal with depth soundings. Published by the U.S. Coast and Geodetic Survey, reissued in 1940. So, again, official American map of the Philippines, so they were here, showing Scarborough Shoal. Next slide. Now, before that, what happened in 2012, November, when China seized the Scarborough Shoal, the U.S. said, we do not take sides in territorial disputes in the South China Sea. They were saying Scarborough Shoal does not belong to the Philippines. But in their own map, shows that. And even in their own documents, as I will show later. That's Scarborough Shoal. It's about 1.2 meters above water at high tide. About 4 to 5 rocks. The biggest rock, the South Rock, is about here. 1.2 meters above water at high tide. At high tide, just 1.2 meters. So it's none, it's territory. It's entitled to a territorial space. Territorial sea. That's the territorial sea, 12 nautical miles. How big is that? If you compute the surface area of 12 nautical miles around it, it's 155,000 hectares of territorial sea. That is more than twice the land territory of Metro Manila. Metro Manila has only 63,000 hectares. This one is 155. So a small rock like that under international law is a very big territorial sea. That's why countries fight over a rock, even if it's only 7 inches above water at high tide. Now this is Okinatorishima. Japan is claiming this rock here. But how big is Okinatorishima? Okinatorishima, this is the rock. It's only about 7 inches above water at high tide. To prevent erosion, this structure here, with these rocks here, so that it will not erode. The moment it erodes, no more. Japan spent $600 million because there are 3 rocks here that they protected. Very important. That's why we have to fight for every inch of territory above water at high tide, because it's huge. Okay, next slide. You go to the Chinese embassy website, and China claims that Scarborough Shoal belongs to them because the shoal is allegedly the Nanhai Island that Gu Sujing visited in 1279, and where he erected an astronomical observatory. Let's go to the Beijing Review. That's the Beijing Review, Chinese sovereignty, and this is a quotation from that review. The astronomical observation point Nanhai was today's Xia Islands. It shows that Xia Islands were within the bounds of China at the time of the Yuan Dynasty. So when the Chinese were quarreling with Vietnam over Pamantasan, they pulled out Gu Sujing. Here is Gu Sujing. He visited that. Now that they're quarreling with us over Scarborough, they pull out the same Gu Sujing. That is the island that Gu Sujing visited. Now, Gu Sujing is a brilliant guy. He was the Leonardo da Vinci of China at the time, brilliant astronomer, mathematician, engineer. Okay. He built 27 observatories, 26 on mainland China and one in Nanhai. Nanhai in South Sea. China doesn't call the South China Sea as South China Sea. It calls it Nanhai or South Sea. So, and he put up one observatory in Nanhai. Could he have put it in Scarborough Shoal? Now, there is one existing observatory built by Gu Sujing, one of the 26 of the mainland. You can go there and see it. It's 12.6 meter high. There is a sundial. To operate this, you have to be there every day of the year to measure here and to measure the astronomical. There are astronomical instruments here. This guy, Gu Sujing, created a calendar more accurate than the European calendar at the time. Brilliant guy. But could he have put this in Scarborough Shoal? That's Scarborough Shoal, 1.2 meters above water at high tide. The Asian one is 5 to 6 feet. Proportionately, if you put that there, you cannot. If Gu Sujing was able to do that, it would have been a greater engineering feat than the construction of the Great Wall of China. Last September, an earthquake of great significance happened. It's a political earthquake that moved the tectonic plates of the South China Sea. Why? President Ma of Taiwan, he belongs to the Kuomintang government. Remember, the Kuomintang government was the government of the mainland in 1947 that invented the 9-dash line. And he said that the 9-dash line was a claim only to the islands and their adjacent territorial sea. 3 at the time of 12 nautical miles. Ma said there was no so-called claims to sea region. Ma said we did not claim the sea. We only claim the islands and the North Territorial Sea. So there is now a divergence of interpretation. Mainland China says the 9-dash line is a claim to the entire waters of the South China Sea, including all the islands. Redma said no, it's only a claim to the islands in the territorial sea up to 12 nautical miles. Why did President Ma say that? Now Now, if you look at the original map, this is the original map in 1947. The title is Location Map of South Sea Islands. But the guy didn't go there, so he just assumed it was an island, and it was Zhongsha Island. Now, there are several features here around Zhongsha Island, but none of them is Wangyang Island, or Mizu Island, which is the second name of Wangyang Island. So even in the 9-dash line map, there is no Scarborough Shoal. Next slide. What is the legal basis to claim Scarborough Shoal? Under the 1898 Treaty of Paris, they drew those lines, rectangular lines, and Spain ceded everything within the lines. The U.S. paid $20 million. The treaty included, by the way, Guam, included Puerto Rico. Now, Scarborough Shoal is outside of the treaty lines. But people forget that there is a second treaty, the Treaty of Washington of 1900, wherein Spain clarified that it also relinquished to the U.S. all title and claim of title which Spain may have had at the time of the conclusion of the Treaty of Peace of Paris to any and all islands belonging to the Philippine archipelago lying outside the lines. So here is a casual provision. Everything that Spain owned, whether inside or outside of the lines, we also see that. U.S. paid an additional $100,000 to Spain for this treaty. So, Scarborough Shoal was ceded by Spain to the U.S. in the Treaty of Washington of 1900. Okay, next slide. During the Commonwealth government, even our leaders at the time were worried that other countries might claim Scarborough Shoal. They wanted to put up a lighthouse to assert our sovereignty. So they wrote the U.S. Secretary of State, Colonel Howe, and Secretary Colonel Howe replied. He wrote a memorandum to the Secretary of War to inform the Philippine government that because of the absence of other claims, the shoal, Scarborough Shoal, should be regarded as included among the islands ceded to the U.S. by the American-Spanish Treaty of November 7, 1900. That's the Washington Treaty. So here is an express admission by the U.S. State Department that Scarborough Shoal belongs to the Philippines. What happened in November 2012 when China seized Scarborough Shoal? The U.S. said, you don't take part in territorial disputes because if we insisted, then the Mutual Defense Treaty would have been triggered because this is an island under the jurisdiction of the Philippines and it was being invaded. Okay, next slide. We exercise effective, continuous, open public sovereignty over Scarborough Shoal from Spanish time up to now, next slide. From 1960s to 1980s, Scarborough Shoal was used as a cannery range by Philippine and American warplanes and warships. We issued notices to mariners worldwide through the IMO, and the IMO distributed this to all nations that there is a gunnery exercise by the Philippine Navy, by the American Navy in Scarborough Shoal. Stay away. We issued a notice to mariners. China never protested. No country protested. For more than 30 years, we were doing this. So, notices were sent. China received these notices, it never complained. If your territory is being bombed, you will protest definitely. You will complain. Nobody protested. Now, there are some writers, including Robert Kaplan, who said that, let China do this, claim the South China Sea, because the U.S. also claimed, the U.S. had a Monroe Doctrine. This 9-9 is the equivalent of the Monroe Doctrine. In the Monroe Doctrine, however, the U.S. never claimed any part of the Caribbean Sea or any island or rock. The doctrine merely declared that the U.S. considered it an act of aggression against itself if European powers re-established their colonies in South or Central America, or if European powers interfered in the political affairs of independent states of the region. That was the Monroe Doctrine. The U.S. never claimed the sea, never claimed the Caribbean Sea, never claimed an island or a rock. The Monroe Doctrine was vintage 1823. In 1823, there was no United Nations, there was no International Court of Justice, there was no UNCLOS. The use of or threat of force at that time was recognized as a legitimate means of acquiring territory or settling territorial dispute. You go to war. If you win, then it's legitimate. Whatever you acquire is legitimate. That was 1823. You cannot do that now. Under the UN Charter, wars of aggression have been banned. You cannot settle the territorial disputes by war. That's whatever you acquire by war is illegal. It cannot ripen into ownership. So you cannot invoke the Monroe Doctrine. That's a different era. And besides, the U.S. used the Monroe Doctrine to eventually interfere in the internal affairs of Latin American countries. We don't want that. None of the Asian countries want that. So we should reject any invocation of the Monroe Doctrine. That's a totally different era. Now, what is China's core objection to our arbitration case? This is a quotation from the position paper of China. China is saying that we have brought an arbitration that involves a dispute of maritime delimitation between two states. Maritime delimitation between two states. Because under UNCLOS, a party can exclude itself from arbitrary compulsory arbitration by making a reservation, but with respect only to sea boundary delimitations. Now, that is correct. The dispute is about maritime delimitation in the states. The arbitration that we filed is about dispute is, That is correct that it can invoke dispute of maritime delimitation between two states. However, what we filed is not about maritime delimitation. We are not asking that. We're not saying that there is an overlap between the territorial sea, between the EEZ or continental shelf of China and the Philippines. This is the provision. Article 298 allows exclusion from compulsory arbitration of disputes concerning the interpretation or application of Article 15, 74, and 83 relating to sea boundary delimitations. What we are saying, China cannot invoke 298 because 298 refers to sea boundary delimitations involving overlapping territorial sea, overlapping EEZ, overlapping continental shelf. That's not the situation. That's why we're saying China cannot invoke this because their case does not apply to this. 3 articles. China does not claim the waters enclosed by the 9 territorial sea. Now, China says sui generis. If it's sui generis, then it's not territorial sea, it's not EEZ, and it's not continental shelf. Next slide. Okay. UNCLOS also says, Article 309, no reservation or exception will be made to this convention unless expressly permitted by other articles of this convention. Article 298 expressly allows reservation with respect to overlapping territorial sea, overlapping EEZ, or overlapping continental shelf. It does not say overlapping sui generis waters with EEZ waters. None. So, and under 309, you cannot make any reservation or exception unless expressly permitted. And what is expressly permitted are only overlapping territorial sea, overlapping EEZ, and overlapping continental shelf. Now, why is it important to apply UNCLOS to the South China Sea dispute? Because if we allow China's 9 lines to stand, it will gobble up the EEZs of coastal states, as well as the high seas. Then UNCLOS, the Constitution for the oceans and seas of our planet, cannot apply. If it cannot apply in the South China Sea, it cannot apply in any maritime dispute in the rest of the oceans and seas of our planet. It will be the beginning of the end of UNCLOS. It will create a naval arms race, and it's already happening now. Why does a state claim an entire sea? No state, except China, is claiming an entire sea. This debate happened in 1609. In 1609, Hugo Grotius wrote Mare Liberum, the Free Sea. And Grotius took the position that the oceans and seas of our planet belong to all mankind. It cannot be claimed by a state, cannot be owned by a state. What Grotius wrote became the foundation of the law of the sea, and because of his other writings, like his writings on the laws of war, he is called the father of international law. Now, China is resurrecting the debate. 300 years later, China is resurrecting the debate and is quoting John Selden that China can claim the entire South China Sea. That debate is long over. We have now UNCLOS. You cannot own an entire sea. You can only claim 12, 200, 150 additional. I end with this question. I call it the Grecian question, and I always ask this question. Will the world community allow a single state to rewrite the law of the sea so it can exercise indisputable sovereignty to almost an entire sea? Subject the high seas to its sovereign jurisdiction, seize large areas of other coastal states' EEJs, which are their legal entitlements, maritime entitlements of the regions. With that, I end my presentation. Thank you very much.